Hello, everyone. We're back with episode 38, and our guest speaker is Edward Lee, professor of law at Santa Clara University. And we are excited to have you today for this conversation because who else would we discuss this, Elisa, with? Because it's that the news has been pretty crazy lately, and who knows? By the end of this discussion, there will be possibly another lawsuit coming. Who knows?
That's
Oh, yeah,
that's
Edward,
the that's the
welcome.
possibility. That's the possibility. Yeah, we're so lucky to snatch Professor Lee, especially in the end of the school year when he was grading all these papers and dealing with everything that a law professor needs to deal with at the end of the semester. So, Edward, thank you so much, and we'll just let you introduce yourself and tell our audience, what you do in addition to teaching law and all these projects that you have, and yeah, so please passing the baton to you.
Well, thank you, Alyssa, and thank you, Elena. It's a pleasure to be here. I have finished my grading, just for the record, so it is delightful to be in this podcast to be able to talk about the AI copyright lawsuits. I am a professor of law. I teach at Santa Clara School of Law, and since 2023, I've been following very closely, tracking the copyright lawsuits that have been filed against AI companies. Now they're already up to 41 lawsuits. So since 2023, we've seen quite a number of companies being sued. And we're going to show a map shortly, but a lot of the activity around the coasts, the West Coast and the East Coast, have the most lawsuits in the Northern District of California, and then also in the Southern District of New York. And I know we're going to talk about some of the bigger cases at the moment, but just to keep things in perspective, it started 2023, and we barely have any resolution, except for one case that had started even earlier, Thomson Reuters versus Ross Intelligence. That was a pre-generative AI case, so to speak, and it has been decided on summary judgment, and we'll talk a little bit about that later. But all this goes to show that litigation takes time, and yet AI is rapidly developing. There's so much discussion about agents, AI agents, eventually robots. So the law just moves slowly, basically, and we will not likely have a definitive answer on the big question of whether AI training is fair use until it hits the Supreme Court. And that probably is, at the earliest, several years away, if not more. And just imagine, let's say 3 years from now, just how advanced AI is likely going to develop into. So
I was gonna say that by that time, possibly that technology, the decision will be on, probably might be outdated. So but
yes,
we'll get some sort of resolution.
yeah, exactly. Yeah, the litigation does involve the models that have been developed since 2022 or so, ChatGPT being the most famous one, with OpenAI's model that launched in December 2022. But if we jump forward to the year would be 2028, just think what the state of AI models will be at that point. But the litigation is based on past conduct, right? Conduct alleged to have occurred before the filing of the complaint. And that's how the evidence will be presented relating to that past conduct. So it's quite interesting. And I see you're showing
Oh
my
yeah,
website.
absolutely. Because I mean, really, everyone and their mother is using Edward's copyright AI copyright lawsuit tracker, because Edward is watching the dockets for us. Literally, he does, and he's built this website that's conveniently call ChatGPT is eating the world. And so this is just a cute robot, I guess, consuming, whatever it is that it is consuming. But yeah, I mean, since Edward, since you're giving this overview, yeah, I just wanted folks to show folks some of the content um, um, from your lawsuit tracker, and that's what it is. So basically, that's the overview of the world stage at the moment, right? So if you wanted to like touch briefly on that, just kind of set the stage for the U.S. Copyright discussion.
Sure. What I think this shows is that most of the litigation is in the United States. So the United States has 41 lawsuits. Outside the United States, it's, by my estimate, 11 lawsuits involving copyright claims. Part of the reason is the sort of big AI companies are based in the United States, Silicon Valley, almost entirely. I think I'm trying to think of the locations of all of the startups, but I think Silicon Valley, nearly all, if not all of them, are based in Silicon Valley. And then the second thing that I think is a factor in why the United States is the hotbed of activity. Most other countries do not have fair use as a doctrine in copyright law. It's an American doctrine. It originated in the United States, developed by judges, is a judge-made doctrine. Congress codifies it in 1976 in Section 107 of the Copyright Act. But it is, distinctively an American doctrine. Now, some countries have since adopted it. Israel, South Korea, I believe, are two. There may be a handful or so, but most countries do not have something like fair use, which is this very open-ended exception to copyright infringement. And in the United States, the Copyright Act has codified 4 factors that are non-exhaustive for courts to consider. So it's a very flexible doctrine, and it was enacted in part because Congress anticipated there would be disruptive technologies. So it's not surprising that the lawsuits concentrate in the United States, because we do have this doctrine, fair use, which provides at least an arguable basis for these tech companies to say what we did was a permissible fair use to train an AI model. Now, obviously, the plaintiffs disagree with that interpretation, but once we have a very flexible general exception, that means that this issue is a novel or a new issue of law. We don't know the answer yet, and that explains why there are 41 lawsuits in the United States. It's like there's not a clear answer. We can just look at the statute and say, oh, that's not permissible at all. We look at the statute and also the case law and say, well, it's case-by-case determination of fair use. And flipping over to the United States map, this shows you the 41 lawsuits. One thing to highlight that maybe some people are not aware of watching the podcast is that OpenAI successfully got the transfer of all of the lawsuits against it to the Southern District of New York Judge Stein, Sidney Stein, sitting in what's called multi-district litigation court, which is a procedural device in the United States that is meant to consolidate, for pretrial purposes, multiple litigation involving common sets of fact. And here, the common sets of fact are OpenAI engaged in training of its model. And Microsoft is in some of those lawsuits as well, since Microsoft has a partnership with OpenAI and uses OpenAI's model for its own Microsoft software programs. So in any event, the lines
No.
that are arrows pointing to the New York from the West Coast are transferred cases over to Judge Stein.
And I believe he presides over 13 cases, right?
Yes, which makes him incredibly influential. I mean,
Yes.
what could have been, I don't know,
Uh-huh.
let's say it could have been at least 5 different judges in different cases. He now is for the pretrial. Now, whether there is a bellwether trial or not before him, remains to be seen. But for pretrial, what's important is the summary judgment motions. And we should expect one of those summary judgment motions will be on fair use, raised by both OpenAI and Microsoft. So Judge Stein will be the decider of that on summary judgment. Now, the other thing I should caution is it's quite possible some judges say there are disputed facts and we need to have a trial. Even on, let's say, fair use, they might say, well, the evidence of market effects under factor 4 based on this AI training, there's some dispute of fact and this should go to trial. So, it could go either way, but we'll have to wait and see.
Yeah, and I also
Sorry.
quickly wanted to add that I believe Judge Stein made it clear that it's going to be his final year as a judge. So essentially, we got to have some sort of resolution from him. That's what in my understanding, that's what I heard. So.
I think you're thinking of Judge Alsup in the other case.
Oh, okay.
Yeah,
Probably because I literally just heard it. Yeah.
I don't know. I mean, the only one that I'm aware of, but if you just heard it, maybe there's a different news. The only one that I heard of is Judge Alsup in Bartz versus Anthropic. He recently indicated, yes, he intends to go inactive before the end of the year. And he does have he does have a motion for summary judgment on fair use that has been fully briefed, fully argued. So he could decide that, any minute now. There's another case too. The other case that has been fully briefed and fully argued on summary judgment for fair use is the Kadri versus Meta case, and Judge Chabria has had that case argued since May 1st. So it's been a month, over a month now. Who knows how quickly an opinion issues? But both of those cases, I think, sort of everybody who is following these lawsuits is waiting with kind of bated breath, like, when's the next decision to come down?
So, Edward, I have a question. So basically, for folks who are not maybe well-versed with civil procedure, maybe not lawyers, can you please explain the significance of, the transfers, like are the plaintiffs forum shopping, and also what the summary judgment is? It's just like simple terms, because sometimes we tend to, kind of be in our little bubble. But I just wanted folks in our audiences to understand the significance of summary judgment concept and why is that important?
Yeah, let's just start first with the second point about summary judgment. It is a procedural mechanism for the trial judge to basically decide the case without a trial. And the judge can do so if the genuine issues of material fact are undisputed. Both sides agree that this particular fact happened. Okay, so there's a statement of undisputed facts in these motions for summary judgment. And then the judge has to determine, based on what's undisputed, does the law say that one party prevails applying the law? So here the relevant legal issue is the fair use defense under Section 107 of the Copyright Act. And let's just assume that in the recitation of undisputed versus disputed facts, the judge agrees that the material facts are all undisputed. And based on those undisputed facts, I'm going to decide and apply the principle, the factors of fair use and rule on it. And, that has happened in past cases. So there's nothing extraordinary about doing that. Judges have granted summary judgment for fair use in many cases before. Now, if there is a disputed material fact that is relevant to determining, let's say, market harm under factor 4, that's when the judge is not supposed to, resolve any factual issue and should send it to trial. It should go to a trial. And we've also had trials on the fair use defense. Probably the most famous one relatively recently is a case involving Google versus Oracle. And that case was tried actually before Judge Alsup, who is presiding over Bartz versus Anthropic. So he's very, I think, familiar with fair use in technology cases, and he's very, he's been on the bench for a while, very familiar with trial, but also he did mention at the hearing he was leaning toward finding fair use, although he cautioned he could change his mind. But he gave the parties some indication of his current thinking at the time of the hearing. Oh, and then the other second issue that I spoke probably for too long, but the second issue was how does a transfer occur in these lawsuits involving OpenAI? It's just a special procedure where there are multiple lawsuits involving a common set of facts that enable, in different courts around the United States, federal courts around the United States, one of the parties, if not both of them, can petition to have this so-called multi-district litigation court consolidate all of the lawsuits before one judge. And that's what happened here, because as I said, all of these lawsuits involve the common set of facts involving OpenAI. What OpenAI did in training was the same for all of them, right? All 13, OpenAI trained its model using copyrighted works. So it's a matter of judicial efficiency and economy, and also for the parties too. You streamline the litigation and avoid, let's say you avoid multiple depositions of the same witness. Why would you want the same witness to sit for a deposition in 13 cases when it involves the same set of facts? So in any event, this is a procedure that will help to save the court's time and resources. It will help to save the parties' time and resources, especially here, the defendants, OpenAI and Microsoft.
Discovery should be fun.
Yeah. So there is.
Can we talk about that a little bit?
Yeah.
We kind of briefly discussed it during.
Yeah, we have a recent development on the scope of discovery, which is very interesting.
Yeah, I mean, you're referring to the user logs for ChatGPT.
Oh yes.
Yeah, so the newspapers and New York Times, there are other newspapers involved as well. They recently filed a motion to have OpenAI preserve all of its user logs of chats. So if you're today using ChatGPT, your log uh, might have to be, well, actually, it has to be stored now because the magistrate judge Wang agreed with the New York Times motion that for the time being, at least, she ordered OpenAI to preserve all of the output logs because the New York Times alleged that OpenAI may have destroyed some logs that were relevant to the discovery motions that it filed, and and it should have been preserved. Now, I think OpenAI has disputed that in its response, and they also have petitioned just yesterday, I believe, or 2 days ago, Judge Stein to overrule that decision by the magistrate judge works with Judge Stein. So OpenAI, definitely is opposed and objects to this discovery order, which does strike me as it's a lot to.
A little overbroad.
A little
Yeah, I mean, it's a lot to preserve. And one of the things that OpenAI mentions is, it has given users the ability, for privacy reasons, not to have their their chats, preserved or saved. So obviously, it becomes interferes with that sort of option if they are now required, for at least for the time being, to preserve everything. So that I think certainly is one concern, in addition to the massive scale of having to preserve what OpenAI says is like tens of billions of chat logs to preserve it. So we'll have to see what Judge Stein says. That should be, I think, something that happens relatively soon in the near future.
Yeah. And also it's interesting, and you mentioned that as well during our prep call, the scope of discovery. So there's kind of this fighting going on between the parties, like what's the appropriate amount of, of samples to be disclosed. That some companies are arguing 1 million should be enough, 1 million tokens, 1 million.
And that's
other companies are just like, let's do it 5, let's make it 2. So it's good. The plaintiffs obviously are leaning more on the bigger number. So it's just really interesting dynamics right now.
Yeah, especially when you have these AI generators and there are potentially hundreds of millions of users and so much activity. And in reference to, Elena, your comment, the New York, OpenAI did point out that in another lawsuit, Bartz versus Anthropic, that there was this sample that was used or ordered as the permissible discovery of relevant outputs to searches conducted on Anthropic's Claude. And the dispute was between 25 million was the proposed sample by the plaintiffs, the book authors. 1 million was the proposed sample by Anthropic, and the magistrate judge Van Keulen said 5 million output from the searches should be enough to conduct a survey of the outputs to see what Claude potentially outputs. And what the Concord Music is seeking is some indication that it has their lyrics of musical works. What do these outputs what do they generate from the searches that are going to be in the sample? So by comparison, if we're thinking about preserve everything for the time being versus something in the order of 5 million, that's going to be a huge difference, especially because OpenAI says it's receiving tens of billions of chats, and I'm not sure what the time frame is, but it probably, it's probably very short time span, like, daily or weekly or, something of that order. So, that's just going to escalate until there is a final decision on the scope of what they have to preserve. And as I said, I expect Judge Stein is going to, uh, well, OpenAI wants an oral argument on this. They're very concerned about it. But I expect Judge Stein will be proceeding forward on this motion.
Yeah, as they say, watch the space.
Yeah.
So,
Go
yeah.
ahead.
No. I hijacked you first.
Yeah. I just wanted to, because I mean, we're talking about this copyright claims, heavily fair use discussion and analysis. But actually, what we've seen over the last couple of years is that when plaintiffs started filing these lawsuits, they basically threw a bunch of claims in there. And what we've seen, and Edward, I would like your comment on this one, is that we've seen those claims being dismissed through pretrial motions as we move forward. And basically, I call them like winners and losers, right? So right now, I think we still have some lawsuits, and I think the recent one with Reddit, right, which was not even the copyright kind of a claim. They had I think breach of contract, unjust enrichment, trespass to chattels. That's our favorite one.
Exactly.
So what's your take on that? I mean, because we've seen, I thought at some point the pendulum was swinging kind of a back and forth, and we didn't kind of know where the judges would be inclining to go. Right now, we feel like copyright claims are surviving. We even have summary judgments already on some of those claims. But what about all these other guys that are kind of piggyback on on the copyright related issues?
Yeah, I mean, I think of these lawsuits depicted on this map, the 41, by and large, the state law claims have gone nowhere. I think primarily dismissed. I'm not sure if there are pending lawsuits in which they've survived a motion to dismiss filed by the defendant. So really, we're talking about federal claims, putting aside the Reddit case, because that didn't even involve a copyright claim. It's all state law, as you mentioned. And I did some quick research before today's presentation, and past lawsuits also have not fared very well just on data scraping. But I haven't been able to exhaustively research those cases. But turning back to these lawsuits, I would say the federal claims that seem to survive most motions to dismiss and seem to be marching forward are, of course, direct copyright infringement based on the AI training involving use of copyrighted works. There are roughly, I would say, 35 or so of these lawsuits that have that claim. Then the second pretty popular claim that has somewhat mixed results, but in some lawsuits has survived, is the so-called DMCA copyright management information removal claim under what the section is 1202B, and the one that has the best chance of survival based on what has happened is it actually has three subsections. B1, intentional removal of copyright management information. That one has survived in some of the lawsuits. And for the audience, if you're not familiar what copyright management information, it's just information related to a copyrighted work, including the author's name, title, a copyright notice, publication date, that kind of thing. Anything that the author is placing on or in association with a copy of the work becomes copyright management information. And Congress enacted this provision back in 1998 as a part of a bigger amendment to Congress to provide some protection from people intentionally removing that information in conjunction with infringing activity. So, for instance, there's a case involving removing the credit to the photographer on a photograph and posting it online, and maybe even like putting in somebody else's information there. That would be a violation of DMCA CMI claim. And that is I think the second, probably most popular claim that has received some traction after motions to dismiss. And then the final one that I'll mention briefly, which is kind of I don't know, it's a sleeper kind of claim. In the lawsuit involving Stability AI brought by the visual artist, Sarah Anderson and others, Judge Oreck did allow the Lanham Act claim for false endorsement and potentially vicarious trademark infringement for the alleged use of the names of the artists in the model to generate output in the style of that artist. And the artists are claiming that they have distinctive style as trade dress. And at the motion to dismiss stage, interestingly, Judge Oreck said that was sufficient to be a trademark type claim. And so there are also trademark claims in a few other cases, but that one comes to mind because I think Judge Oreck was the first federal court to rule on the viability of Lanham Act claims in this context.
Yeah, Studio Ghibli comes to mind immediately.
Yeah,
At least for me and like for all the fans of Miyazaki art and those styles. And no one sued anybody yet, but yeah, I guess that would be something within the same kind of a domain, and the trademark analysis maybe.
Potentially.
So,
I actually think, I mean, this relates to when OpenAI launched a improved version of its model for ChatGPT. It then could do text-to-image creation, and Sam Altman, the master of public relations, changed his avatar on Twitter, X, to an image of himself in Studio Ghibli style. And some of you may have seen what happened. Then like everybody started doing it, and then it flooded X or Twitter, and even the White House had a Studio Ghibli image that it posted on X, and I may be in the minority, but I wrote briefly about this controversy on my website. I think there could be a viable claim. Now, we're assuming there was no permission and this was not licensed. We have no idea whether anything had been cleared ahead of time, but assuming it was not, I actually think that there's at least a plausible copyright claim. And I think the reason is the word style is often used to describe various different things. And if we're talking about a music style, let's say country, nobody can copyright country music. That's that style. That's totally correct, right? But when we're talking about style that is comprised of certain elements that one artist has developed, like Saul Steinberg of The New Yorker, that's the famous case involving Steinberg, and I think Paramount Pictures was the defendant. The district court judge said, style is one element of expression, which I think is correct. So it's correct in the sense that if the illustrator has used elements over and over again, and that particular selection and arrangement becomes a part of the characters or the illustrations that he has or she has constructed or created, then it's quite plausible. Somebody thinks, oh, all I'm doing is copying the style of Saul Steinberg, but you're also copying the copyrightable elements. The court said in that case. So my one sort of word of caution in thinking about style is that we have to figure out what is the definition of style as used here. Are we talking about a generic style or a general style? Or are we talking about a style that actually is to encompass specific copyrightable elements of, Saul Steinberg, let's say? And that's what I would say with Studio Ghibli is potentially Studio Ghibli has certain styles for all of its characters, right? And if you start borrowing them and enough of them, that's when things, I think, become more dicey because I think it potentially could be copying copyrightable expression.
The words market dilution come to mind when we hear that.
Don't get me started on the market dilution.
This is actually a great segue into that. So do you want to talk about?
We will get you started, Edward.
Judge Chabrias.
Point of this discussion.
Yeah, Judge Chabrias' recent opinion on that, and also, I guess we'll get to the U.S. Copyright Office, I guess, later, because it's also been a huge drama and lots of discussion about this one because Copyright Office plays an important role in all of this, right? So, Edward, if you want to kind of talk about this a little bit, the market dilution. Again, just going back to the, I guess, fair use factors, analysis and, copyright-related federal claims.
Yeah, I disagree with this new theory of so-called market dilution or copyright dilution. For those who are not IP specialists, dilution is a concept and an actual federal claim under trademark law, under the Lanham Act for famous marks. It is sort of being transposed to the copyright context under this fourth factor of fair use for the potential market effect on the copyrighted work or its derivatives by the defendant, the use made by the defendant. And I think the proper analysis is the potential harm to the original or derivatives must come from a copy being used by the defendant in a particular work. So if you make a new song and if you borrowed Taylor Swift's, some copyrightable expression from Taylor Swift's song, well, then potentially it could be a competition to Taylor Swift's own song, right? Depending on how much you copied, and it becomes, now it's hard to become more popular than Taylor Swift, right? But let's imagine somebody did, and they could be substituting for Taylor Swift's song, no matter how hard to believe there would ever be an artist who could do that. But that's what I think market harm under Factor 4 is concerned about. The potential harm by the copy being used by the defendant in a substitutional or competing work. What this new theory out there that has been proposed and the Copyright Office has endorsed it without, I think, much analysis at all, is the idea that the harm can arise from a work, from an output of AI that has no copy in the work itself, but is merely in the same style or genre of the work. So let me just give you the one example from the Copyright Office report, which hopefully I think it shows you just how broad and controversial this is. The Copyright Office said, if the AI model was trained on romance novels, and then the generator produces a romance novel that is non-infringing, it contains no copy of anything from the materials in the training materials, other than the format that this is dealing with romance. That is dilution, according to this new theory, which stretches the notion of copyright, I think, beyond its constitutional bounds. The Constitution then says the copyright or exclusive right can apply to the author's expression. But if the output of AI has no expression in it, that's not proper for copyright to say that that is something that copyright protects against, the use in a non-infringing romance novel. The other example the report used was music, and basically it agreed with Universal Music Group's argument. They're in two different lawsuits suing Udio and Suno, and their comment to the Copyright Office was, any AI generated music competes with, potentially dilutes our music on which the models were trained, in any genre of music, because the argument was like, any song is substitutional for every other song. That's just how broad it was. And I think, again, I think that's stretching the permissible constitutional bounds of copyright to consider as something that is harmful, that has no copied expression in it. That's what is one of the controversies out there. Now we'll have to see if this is something that I don't know if Elena or Elisa who mentioned Judge Chabria, but Judge Chabria did toy with or question something similar to this notion, and it's not clear if he had where he was going to come out. He was concerned that AI generators can produce works so quickly and in so much quantity that it would make it difficult for the next Taylor Swift to make it, basically. But he did question whether this theory was even presented by the Kadri book author. So we'll have to see. But this is definitely a new theory that is being argued right now, and the Copyright Office even said this is uncharted territory. So I don't think I'm mischaracterizing the newness of this theory. This is not something that comes from prior case law or the statute, by the way. This is not something you can't point to the fair use provision and say dilution is a cognizable harm.
Yeah, and considering the amount of AI slop that's been happening, and that's gonna increase even more, obviously. Yeah, it's gonna be very interesting how the courts we'll address that as well. How can you police that? What are the rules supposed to be for? How can you control AI slop, right? It's just, yeah, it's very interesting. Case by case basis, 4 factors of fair use.
Well, I don't know. I mean, just a quick response. I don't know if we need to police it in the sense that I'm not sure if I think these concerns are exaggerated. Just to point out, romance novel market is booming right now, and yet there are all these generators, right? UMG had sort of beat expectations this first quarter with revenues. So, it's okay to fear maybe that this might have an effect. In a court of law, you have to prove it, right? You have to prove, even putting aside whether or not this is cognizable under the statute. So let's just say, okay, for the time being, we're going to assume it is. And this is what Judge Chabria actually focused on. The plaintiff, if it is asserting a theory of market harm, has to substantiate the harm, right? You can't just say, oh, I think there's going to be a harm. This is one of the lessons that we learned from the Sony Betamax case, in which, the movie studio said the Betamax would, or VCR, would destroy the movie industry, right? Because people could record movies on TV at home. Now, that never happened. And, the fair use in a 5-4 decision was very close. 5-4 decision said recording a show at home to watch later is fair use. And then what ended up happening is the VCR spawned a new market for buying movies on video tapes, as well as renting them, like rental companies buying those movies too. So that's one, data point where we could say, well, good thing the Supreme Court did require substantiation of market harm, because if it were up to Jack Valente, who was the Motion Picture Association president at the time, they would have stopped the VCR. They would have just stopped production of it. They were seeking an injunction against the VCR. So in any event, so I don't know. There are a lot of things that I think technologies enable. In the beginning, I think it's very difficult to predict kind of all of the uses and how those uses will be beneficial or be harmful, that kind of thing. Because I think certainly there are beneficial uses of AI generators. And one that I point to in my article is, I think it is an undisputed fact that AI generators have made more accessible the ability to create in various media, including for people with disabilities. There are sort of high profile examples of that happening, but I'm sure a lot more of it is happening that is not even being reported. So that is one socially beneficial use of AI generators that we should not, I think, simply ignore. And ultimately, I think in the lawsuits, there'll be competing evidence by both sides on the public benefit of AI models versus the market harm to the plaintiff's works. And that's one reason why initially I thought a lot of these cases would go to trial, but as we've seen from one of the cases in Delaware involving Ross Intelligence, and if sort of trying to infer from the hearings in Kadri versus Meta and also Bartz versus Anthropic, it does seem like those two judges in those cases are at least considering the possibility of deciding the case on summary judgment. But in any event, if it is decided on summary judgment, there is a record of what the competing sides think substantiates the market harm or lack of market harm, the public benefits or lack of public benefits.
Yeah, I mean, it is, yeah, from the public and like the more general perspective, as you mentioned, we're going to see how many of these cases will make it to trial, because that's where the trial fact, the jury will have to decide all those things, right? And there will be just regular people, sitting in the jury box and grappling with all this evidence from both sides, which I think will be very compelling, as you have just outlined, right? Like public benefit versus market harm and all these things. So I'm just kind of theorizing and thinking, why some companies would choose to transfer their cases or just kind of forum shopping, because they might think that, some of the judges would be inclined to kind of decide that on the summary judgment motions. So, but I mean, I totally understand, because some of our judges, I mean, especially in the Northern District of California here and in San Francisco as well, they're very, I would say, tech savvy, because they have tried those cases for many years and they know what's happening, even with this very new concepts and just defining this new territory. But I think they are in a better position than the others to kind of make decisions on those very, very novel legal issues, right? So
no, I totally agree.
Mm-hmm.
Yeah, as Judge Alsup, for instance, who has the Parks case, he hears a lot of patent trials. He also presided, I think I mentioned this, over the Google versus Oracle case.
The saga, Google versus Oracle saga. I mean, it was like 10 years in making, right? I remember I was listening to the oral arguments in Supreme Court. I was like, I stopped whatever I was doing, and I just kind of tuned into the audio from the Supreme Court to listen to this, because I think it was kind of a that impact litigation, as we say, right? That kind of defined so many things moving forward. So yeah,
and he had it was actually a trial. He had a trial on fair use, and the jury found fair use of Oracle's Java SE program. So it is possible that some of these cases go to trial before a jury. I was actually disappointed that in the Thomson Reuters versus Ross Intelligence case in Delaware, it was before Judge Bibas, and they made it all the way up to a day before trial.
Oh my goodness.
Yeah. And then he had second thoughts. He had issued an opinion in 2023, and he said, I cannot grant summary judgment because there are disputed facts, and I think one version of the facts, it would be a fair use, and another version of the facts, it would not be a fair use. So they made it all the way up, and the day before trial, he had second thoughts, and he asked the parties to resubmit renewed motions for summary judgment. He postponed the trial, and then he grants summary judgment against fair use. But then after the defendant, Ross Intelligence, petitioned to file an immediate appeal to the Third Circuit because there were still outstanding issues to go to trial, including damages. That issue had to go to the trial before the jury. Judge Bibas did recognize, this is a novel issue of law. It's a difficult issue, and he thought that and it was a dispositive issue. It could decide the entire case, and he thought that an immediate appeal to the Third Circuit would make some sense. Now, the Third Circuit, they have not ruled on that yet, whether they're going to take it, but Judge Bibas sits on the Third Circuit, so I would be shocked if his colleagues did not agree with him that, if he says that this should go to the Third Circuit and they should decide it, that they said, we disagree with you, sorry. But I don't know. Stranger things have happened in litigation, but that would be a surprise to me as well.
Yeah. Can you imagine being called in one of those trials? Because I guess you are within 100 miles, from the federal
Oh,
court.
well, somebody would strike somebody would
They would
strike
strike
me.
during
Yeah,
bombing.
somebody would
Yeah,
strike
it's
me.
like this is.
I have it too opinionated on that.
I guess so. We all would have to disclose, our, I guess, not
Yeah,
bias,
I
but
don't.
just kind of
Yeah,
involvement in those things, and just some prior knowledge, right, and all of that, so which could influence, our decisions as a potential juror, definitely.
yeah, exactly.
But that would be fun.
Oh, it'll be really fascinating.
Yeah. All right.
We have like less than 5 minutes left.
Yeah, I think maybe some of
Can
the
we
things
quickly, yeah, can we quickly talk about like the latest licensing deals that some of the AI generated music companies are, doing and going around, and how it might affect the current litigation in your view?
Yeah, that was news that came out just in this past week by the Wall Street Journal. UMG, Sony, and the name of the third label escapes me at the moment, are in negotiations with two of the defendants, Suno and Udio, the AI companies that have text-to-music generators. And they're actually negotiating a licensing deal for the music. Now, we don't know if they're going to be successful in striking out a deal, but if they do, we should expect they will settle the lawsuits, right? It'll be as a basis, kind of a package deal to allow the use of their recordings related to the lawsuits, to get to extinguish those lawsuits or to settle those lawsuits. So, we shall see if that comes forward. But I think based on the Wall Street Journal reporting, it sounds like they've made some headway. I don't think they would have reported it if this were, something that were just so preliminary that, it had not really advanced too far. So if that happens, if there's a deal, then the lawsuits against Suno and Udio presumably get settled, and they'll engage in a licensing deal. Now, one thing I should say, yeah, we've been talking about fair use all this time, but the thing to remember is that fair use and licensing deals are not mutually exclusive. Fair use can operate in, some contexts. It could provide basis for negotiation, but some of the big fair use cases later turned out to be just simply licensed. I think the one that comes to mind the most is Campbell versus Acuff Rose, involving the parody version of Roy Orbison's "Oh Pretty Woman." And the Supreme Court decision was relatively favorable to the rap group Two Live Crew, but sent the case back below for findings related to especially factor 4, the market harm, on non-parodic versions of "Oh Pretty Woman" that could have been derivative works, what the market effect would have been on that. And then eventually the parties just settled. The parties settled, and that's actually, I should just mention, that's probably not too surprising given in the music industry, especially, established artists, typically license, and they're not trying to make too many waves in the music industry, and so that is, I think, more of a norm. But that just shows that we focus on the legal questions for most of our podcast today, but even if it is a fair use, that would not preclude these licensing deals. And I would argue it would not necessarily even discourage the licensing deals, because these suits relate to specific set of facts that occurred in like 2022 or 2023, 2024. And at the start of the show, we all recognize that 2028, there are going to be so many different developments of the models and what they're doing. So it may turn out to be that licensing for future developments of AI becomes sort of more of the practice, right? So this is not an all or nothing question, right? This is like we should not expect that even if some courts say, or ultimately the Supreme Court says it is a fair use, we should not expect that will evaporate, licensing deals left and right, because I think there's still incentive to strike out deals among major copyright holders like UMG and others.
Yeah, I agree. Licensing is the way to go. Even the U.S. Copyright Office came to the same conclusion.
Yeah, exactly.
In the latest report.
We're not relinquishing these licensing schemes. They're still pretty much on. And I would encourage everybody, just ask for permission. The worst case scenario, the person or the company can say no. You can negotiate something. I mean, it's why not?
Sometimes it breaks down. I think the New York Times and OpenAI were negotiating, and then it stopped.
The very last.
It stopped. They may not see. New York Times may not see it in their interest to license anything. No.
Yeah. Well,
we covered a lot.
Yeah.
And I mean, I wish we could cover for another more hour, but we need to let Edward go. And
let Edward go. Yeah.
Thank you
so
joining
much
us today.
We'll have to do another one when one of the opinions comes out.
Yes, absolutely. So
100%.
We have you on record committing to the next talk. So I just wanted to let everybody know. So this map, everything is clickable here. So you guys can go to Edward's website and just really play with this map and see what's happening, with each and every one of those lawsuits. It's really, really helpful. So I suggest you bookmark it and just kind of run wild with it.
Thank you so much, Edward.
Thank you so much.
Thank you.
Thank you, everyone, for joining us.
Until next time.
Bye.
Thank you, everyone. Bye-bye.